Hello. I'd like to start the first afternoon session. I hope you all enjoyed your lunch and are ready to go again. Okay, so this panel is with two judges from the European Court of Justice and the UK Competition Appeal Tribunal. We decided to sit here because judges feel more comfortable behind a table. So let me first introduce the panelists to you. Judge Marcoulli is the president of the second chamber of the General Court at the Court of Justice of the European Union. And Mr. Justice Roth is president of the UK Competition Appeal Tribunal and judge at the High Court of England and Wales. Our agenda will break down into two parts. The first part, we will have some introductory remarks about the way that the appeal courts operate. And then we will discuss two judgments, the Intel judgment for the European Court of Justice and one of the trucks decisions, the first trucks damages decision by the Competition Appeal Tribunal. So let me start with Judge Marcoulli. Could you please give us an overview of how economic evidence is handled in appeals, perhaps distinguishing between murder appeals and appeals of abuse and cartel cases?
Thank you very much, Philip. Thank you for the invitation from Charles River Association to come here and speak today. Also to be joining Mr. Justice Roth in this discussion. First, I'd like to point out that what I say is my personal view and understanding of the case law and cannot be attributed to the court. So I think if we turn the question a bit, it would be, is it unavoidable that the court would be able to judge without taking into account economic evidence? And I would say, no, it's not unavoidable that the court can do that. But being in this conference, and as I told a friend coming, he said, tu vas chez les économistes, so I'll be careful what I say. So I need to, maybe a little bit, I will need to break it down a little bit. And of course, economics and competition law are inextricably linked. The economic analysis is an integral part of the assessment of competition law. And it was one of the main reasons that the General Court or the Court of First Instance was created at the time, was exactly to help improve the judicial protection of individual interests, particularly in competition law matters. And what we have to set out at the beginning, from the beginning, is that what the court does, what the General Court does, is judicial review. It's a review of the legality of the decisions of the Commission. We're not an appellate body. We don't examine, as you will hear from Mr. Justice Roth, we're not ceased to review the full merits of a case or do a new assessment, a fresh assessment of the facts. We cannot replace the Commission's assessment with our own. We just have to control the errors of law and fact that come in a contested decision. Of course, that changes when we're talking about the full jurisdiction of the Court of Fines, but that's a separate issue. So what is the object of the scope of the review? So it is it's for the court to take into account what the parties bring before it, so to be able to rule on points where the misapplication of the law is claimed or a wrongful determination of the factual basis of the applications of the rules of the treaty. And the court will review in full what the Commission did, both as regards the facts and the law. There is only one limit in making this assessment, and that's the margin of discretion that the court will recognize for the Commission. And it is for the court to retain, to find an illegality when the assessments of the Commission are manifestly wrong. And this has been the level of what the review is about, and it hasn't changed. Although I will explain how, in practice, what the court does is goes probably more in depth as time passes by and as the nature of cases change. And how does the court go about doing such a manifest error of assessment appreciation? I think it's been widely accepted, and the court has been using that as a very useful benchmark, a test, and that's the test set out in the Tetra Laval case of the court concerning a merger case. And I think what needs to be retained there is that the community courts, the court said that the general court has to establish whether the facts relied on are factually accurate, reliable, and consistent, that all the information is there for the Commission to take its decision, and that whether the result, the conclusions drawn can be are substantiated by that information. And there, I think it's a test that actually seems perfectly logic in its construction, because how can you uphold an administrative decision which is not based on factually accurate, reliable, or consistent evidence, does not include all the information, or is not the conclusions are not properly substantiated, what is drawn from it? And I think far from, especially in the past few years, aside the fact that the court will not refrain from reviewing both facts and law in the cases brought before it, I think we have stopped seeing also criticism of the sort of lack of judicial review or deference towards the administration. I think the margin of discretion that the court recognizes to the Commission has been adapted to the construction of this test. And I think the point of departure where the court starts is, of course, the contested decision on one hand, and the different kinds of competition. There are different kinds of competition decisions. And of course, as far as the standard of review has not changed, so we're always referring to the manifest error of assessment standard of review. The court has, especially recently after the CK Telecoms judgment, drew a distinction between what is required from the Commission in the assessment of merger cases and what is required, let's say, impliedly explaining what is also required in antitrust cases. Just putting a bit more in its reasoning the fact that merger control is a prospective analysis. It contains events that and developments that are likely to happen in the future, which makes it more less certain than an ex post analysis in antitrust cases. So while it hasn't touched on the labeling of the standard of review, it did recognize that the Commission does not have to meet a particularly high standard of proof in order to demonstrate that the concentration would or would not significantly impede effective competition. But also, having said that, if one looks at the judgments of the General Court in merger cases, and I would just take the Tyson Krupp judgment, it's still a judgment that goes on for about 1,000 points. It's a very detailed analysis of what the relevant market is, what the effects and the commitments are. So it does not mean that by the fact that the Commission does not have to go as far in giving certainty to certain facts, it does not mean that the court will refrain from addressing what is contested by the parties. And there I would go into the impact of the application, what the undertaking concerned will initiate and will bring in its application, contesting the Commission decision. And there it is very important to note that the court will not raise any issues of its own motion, except from some public order pleas, but the perimeter of the application and the contestation of the applicant will have to be defined and circumscribed through the pleas and arguments and the evidence that it will put forward. And of course, it's not with a 2-month deadline of bringing an action. It's always a challenging exercise that we recognize for the lawyers of the concerned applicant, but it is what we have been doing so far. The application has to contain all the elements, as we said. New pleas may only be raised if they are related to issues that have come to light in the course of the proceedings. So all this means that the elements that the arguments put forward will be those that will be examined. So if the applicant will contest on the basis of economic evidence what the Commission did, then that would be what the court will examine. It could be that the applicant decides not to raise any economic arguments. It could be that the strategy of the lawyers is to contest just legal questions. So that's why I'm saying it's not inevitable that we don't go into economic tests. So there I would think that it is for the court to decide how it will deal with economic evidence, but it will be on the basis of what the court would do as regards its unfettered evaluation of this evidence. And it has to be legally obtained, and of course, it has to be the property value, has to sustain the credibility. And making a bit of a research as regards the credibility of such, in cases it will be expert reports, economic expert reports, which are brought before us. And I think I would like to stress 2 points which I found in the Google Android judgment, which could be interesting, that the General Court stressed that the author of such an economic expert report must ensure that he or she sets out his or her qualifications and experience and explains how they are relevant to his or her providing the opinion on the question under consideration. And moreover, in terms of its content, the opinion must be set out the reasons why it should be taken into consideration, whether as regards the reliability of the methodology used or the relevance of the answer given to the question under consideration for the purpose of the case. So, and I would like just to end here by saying that this is usually where the judges find the exercise a panel with no economists on. So just with legal training, find it sometimes more difficult to come into terms with linking the legal arguments with the economic evidence. And I think that's why this, we tried in this judgment just to give a message that it's important to bring in the essence of the economic argument and link it to the legal contestation that's before the court. So just in a first nutshell, just to give you a few points.
Yeah, thank you so much. Yeah, I'd like to turn to Mr. Justice Roth. Perhaps moving on, you know, if you'd like to comment on the, you know, on the cut use of economic evidence, but perhaps also moving on to this very interesting development that the Competition Appeal Tribunal has gone through, that it is now dealing with a lot of damages cases which have a lot of economic substance and a lot of not appeals but standalone cases. Yes.
Yes, thank you. And also, like Anna, thank you very much to CRA for inviting me back to this conference before such an impressively large and distinguished audience. It seems to get bigger every year. No doubt next year you're going to have to rent the Roi Baudouin Stadium to hold your conference in. Now, to your question, the CAT, the Competition Appeal Tribunal, is an unusual court in a couple of ways. Most relevant to your question is the fact that we are an interdisciplinary tribunal. The chair is always a High Court judge or equivalent, but she or he will sit with two panel members, one of whom will often be an economist, and the other may be a lawyer. We have a number of lawyers who were partners in some of the major London law firms, have retired, become panel members of the CAT, or maybe someone from industry or commerce. And that gives us a real benefit when dealing, of course, with economic evidence, because we have on the court an economist, some are academics, some indeed are former consultants who have then retired from CRA or wherever, and Philip one day, and can become on the panel members of the tribunal. Like Anna, there is quite a distinction in the way we deal with evidence, whether it's an appeal from an infringement decision, an antitrust case by the UK authority, the CMA, or a merger case. If it's an infringement case, which can often, of course, involve a substantial financial penalty, that is for the purpose of Article 6 of the European Convention on Human Rights, to which the UK is still a party. We're good Europeans. A quasi-criminal case, and therefore it's very much part of our approach that the appellant has a full right to challenge the finding. Under our statute, it's an appeal on the merits, and the CMA has to call evidence insofar as the point is appealed. Not everything is appealed. So, for example, if it's a Article 102 case, it may be that the dominance is accepted and the appeal is about abuse. But on the areas on which there's an appeal, they have to prove their case, and that will involve calling witnesses, including potentially economic witnesses, and they will be cross-examined, and the CMA and the appellant will have their rival witnesses, and we will hear that in the same way as in a private action. And I'll come on to private actions that you asked about. Very different with a merger case where the standard, and again prescribed in the legislation, is what in England is called judicial review, but judicial review is a technical expression, and it means that really the focus is on the decision-making process, whether that's been fair, and goes into the rights and wrongs of the decision only if it can be said that the decision is really fundamentally wrong on the basis that the decision-maker, as it's often put, failed to take into account something that it should have taken into account, or took into account something that should have been omitted. And that is then the focus of the inquiry. So it's a much higher standard to be met for the appellant, and that is done by looking at the decision, and new evidence then is not allowed, and you would not admit an economist's report even in general on such a case, let alone hear live evidence. And you were hearing before lunch about the new legislation, the UK equivalent of the DMA, the Digital Markets Competition Consumers Act, and there also challenges will come to the CAT, but it will be by way of judicial review. So that very much influences the way our evidence is taken. And we have the full challenge on infringement decisions also for another reason, and that is this: in the UK, as in Europe, in the EU countries, a finding of fact, a finding of infringement by the competition authority is binding in any subsequent private damages claim. And it seems to me that it cannot be right that someone who may be a defendant in a damages claim is bound by findings if they did not have an opportunity before a judicial body fully to challenge those findings. So the challenge can come in the appeal if they choose to bring that appeal. Otherwise, they're stuck with it for the subsequent damages claim. And that brings me neatly to the second part of your question about damages claims. Yes, there's been a huge upsurge in private actions before the CAT. Indeed, someone the other day was referring to us as the Competition Damages Tribunal because we have very many more damages cases now than we have challenges, appeals from the CMA or indeed the specialist regulators. I think there are all sorts of reasons for that, and we've seen damages cases increase, of course, in other jurisdictions, particularly in Western Europe. But the particular aspect that's notable in the past few years in the UK has been the emergence of collective or class actions, which resulted from legislation passed by the UK Parliament in late 2015 and has allowed American-style opt-out class actions in competition law. And after a slow start, we're now getting a very significant number of those. We now have, I think, 57 pending collective actions before the CAT. And while the early ones were follow-on cases after the Commission or the CMA had taken an infringement decision, the ones we're getting now, a significant number, are standalone cases for abuse of dominance.
Do you mind if I interrupt you here? Do you think, or do you feel in any way that these should be reined in? I mean, you know, sometimes when looking at the cases at the CAT, there are these, for example, these boundary fair cases which which are about people traveling beyond a travel zone boundary and then having to pay an excess fare. And then these are opt-out cases, as far as I'm aware, which means that in practice they're financed by litigation financing firms, and if they receive a damages payment, then it goes to the financing firm and the lawyers, as far as I can see, but can be reclaimed, of course, by the.
Not quite, no.
So maybe you can elaborate.
Well, there are no, first of all, yes, most of them are opt-out, not quite all, but virtually all of them are funded by litigation funders. And that's a feature of modern litigation in competition law, where it is so expensive and complex, where the risks of taking on what are often very large companies for whom costs are not an issue are huge, and where in the UK, like I think in all European countries, lawyers are not allowed to work for a percentage contingency fee. So the US model, where it's often the law firm that funds the litigation, doesn't work in the UK or in much of Europe. So other ways are being found to arrange these cases. And litigation funding, not just in competition law, but in other areas as well, in Britain, is one. And I think one may like it or not like it, but there is no doubt that it enables access to justice for small businesses, for consumers, for a lot of the people that competition law is supposed to serve and benefit, to be able to go and get a remedy in the court. So I don't think one should, scoff or be shocked or indeed disapproving of the fact that they're litigation funded. And of course, the litigation funding is a business. They need to get their reward. But the controls do exist in that both on judgment and on settlement, the CAT has to approve what happens to the monies that are raised by damages or payment on settlement, and is very alert to looking at what share goes to the funder or the lawyers, and to make sure that the class does indeed get a reasonable benefit from the litigation. And we're going to see that as the first settlements are coming through. We've had a couple so far. You may have read in the press about the MasterCard Merrick's proposed settlement. It hasn't come to us yet. We'll see what happens there. So it's not the case that it's creamed off by the funders. And is it a good thing? Well, as we were hearing from the speakers earlier, from the authorities, they prioritize. They take certain cases. They have limited capacity. They decide what's important, perhaps for developing policy or where they want to devote their efforts. That means that there are a whole lot of people who may be affected by violations of competition law who get no potential for redress. And therefore, I think the ability to bring standalone cases in the courts, and in our case, therefore, in the CAT, is very important, quite aside from the follow-on cases. And some of these collective actions, as I said, some are follow-on cases.
Yeah, thank you for the clarification. I think we'd like to move on to the second part now, where we would briefly like to discuss the Intel decision, the recent Intel decision, first, and then move on to the first trucks decision at the CAT. So, Judge Marcoulli, I'd like to give you the opportunity to.
Yeah, I will try to briefly set out I wouldn't even say Intel decision, Intel saga in this case, which still goes on. So basically, I think what's interesting in the Intel case, apart from the judicial principles, is also the fact that it gave some interesting clarifications on the as efficient competitor test. And together with other cases that came during the same period, like the Qualcomm exclusivity payments, Google Shopping, or Google Android, it helped to, let's say, clarify the boundaries of the as efficient competitor test, both as regards its substance, but also the procedure to be followed during the administrative proceedings. And then, if I were to briefly start on the Intel decision, where basically the Commission notably relied on the as efficient competitor test to demonstrate that the action of Intel was abusive. The General Court, in its first judgment, considered that in order to demonstrate anti-competitive character of exclusivity rebates, it was not necessary to go into the circumstance of the case. So so it was not necessary to examine the as efficient competitor test. It took a more per se approach to the nature of the exclusivity rebates. There comes the appeal of Intel, and in 2017, the Court of Justice makes a key development in the way that the circumstances specific to economic assessments has to be reviewed by the court, in the sense that the court clarified that if during the administrative procedure there are arguments and evidence that the party that the undertaking concern puts forward in order to prove that its behavior did not result to exclusionary effects, then the Commission is obliged to carry out an analysis to control the capability of that behavior to have such effects. And that, in turn, has an impact on the judicial proceeding. So the court found that the General Court, having not examined the AEC test that Intel had contested, had not performed its review correctly and sent the case back to the General Court. So the General Court, at the beginning of the new examination, so the new judgment, makes clear that the as efficient competitor test is not compulsory to be carried out, but if the administration, if the Commission decides to use it, then it will be examined, and since it had played an important role in its assessment of the exclusivity rebates, it had to be carefully assessed by the court. And concretely, the court went on to examine all the contestations regarding the carrying out of the as efficient competitor test as regards the different companies that received the rebates, and particularly found errors that Intel had managed to cast out as regards the calculation of the contestability of the contestable share to be taken into account in the test, or other errors regarding the fact that the contestable share had to be set at a certain level. So together with other errors regarding the carrying out of the test, the court found that it had vitiated the conclusion of the Commission as regards its finding regarding the effects of the payments, and therefore annulled the decision. This decision of the General Court was confirmed in October of this year. So the court gives some interesting elements as regards the effects of these errors, because what the Commission was claiming was that maybe there are some errors, but they're not such as to vitiate the whole of the appreciation, the whole of the outcome of the AEC test. So the court clarifies that it's not of course, it's not sufficient for the company just to call into question one of the calculations made in the AEC test in order to invalidate the Commission conclusion. It has to be deficiencies and errors that are capable of altering the result, turning it from negative to positive. And that would be the way for an applicant company to cast doubts, reasonable doubts, as regards the outcome of the validity of the test. And that could be either through calculation errors or incomplete consideration of evidence. But it would be insufficient just to call for a mere isolated error to disqualify the whole of the carrying out of the test. And that also interesting what the court did at the end, where the Commission claimed that, yes, there were many other elements in the assessment which could have led the court to consider that the payments did have the effects claimed by the Commission. And the court clarifies one point, that it is not for the General Court to restructure the Commission's decision. So it is not the court to take bits and pieces that could substantiate the outcome of the case. The case has to be judged on the basis of the Commission decision, the way that the Commission decided to put forward its theory of harm and the way the infringement was conducted, and therefore that would be the basis of the assessment. And that would be the outcome in a nutshell of this judgment, which I think gives some interesting elements also for the economists. I think what the Commission, from the other cases, from Google Android or Google Shopping appeal, I think what comes out of those judgments as regards the use of the as efficient competitor test is that, and that's also reflected in the policy brief, that it's not a compulsory, it becomes an optional tool. It's, of course, important to note that when the Commission decides to use it in its assessment of the infringement, it has to be conducted rigorously, and the court will examine it in depth. So I think that are the basic takeouts of this saga, as I would call it.
So in some sense, if the Commission decides to go for a more economic approach, then it will also be held to that approach, essentially.
Yeah, I think that's the conclusion, because it all starts with the Commission decision. It's the court cannot, on its own motion, raise or reassess the elements. Of course, if there are economic elements, as much as it can be challenging, the court will go and examine those. And for that, I think it is for the Commission to choose its way as regards the proving its case.
Thank you. I think in the interest of time, we should turn again to the CAT and Mr. Justice Roth. We decided to spend some time on the Royal Mail BT versus Duff damages case. Perhaps I would like to ask you a number of questions. So the first is actually about the economist on the panel that you mentioned before. So there is a whole discussion in the judgment about the neutrality of the economic experts, and I'm wondering what actually is the role of the economist on the panel? Is it comparable to what we call a court-appointed experts in an intercontinental court, or what exactly does he do?
And no, it's not like a court-appointed expert. The economist is on the panel, and there was no problem about the economist on the panel in that case, I should stress, sure. Is a member of the tribunal with an equal voice in all aspects of the decision. And equally, have the other two members of the panel, so whether it's an economic question or a legal question, it's a decision of all three, unless, of course, one dissents. And inevitably, on legal questions, the economist will sometimes defer to some extent to the judicial chair, and equally on economic questions, certainly the other two members will listen with great respect to the view of the economist. But the economic member of the panel is not the decider on that, but is one of the three. They're very different.
A further element of the judgment was a criticism of the volume of economic expert evidence. I think there were 48 expert reports. So I'm just wondering whether you could give us some tips about how to be more concise.
Well, I think that's actually the failing by us, by the tribunal. We have to control the number of reports and indeed the length of the reports. You can equally get 6 reports of several hundred pages each, which is not necessarily helpful. And I think we took a lesson from that case, that we will in future be much stricter in prescribing how many reports, not just how many experts as we do in any event, but how many reports they can file in answer to each other. We have learned that economists have a great hunger to produce more paper in response to what any other economists say. And we are going to control that more firmly, and indeed we have since that judgment.
So the judgment relied on a lot of econometric evidence. So I'd like you to tell us a little about what the role is of the econometric evidence. Do you see it as a causal proof that a damage has arisen, or what? Or should there be an additional theory of harm that needs to be proposed?
Well, the way it works is, in terms of evidence, is, and this was a follow-on private claim. We're all familiar with the trucks cartel decision of the Commission. Here were 2 very major UK purchasers of trucks, the Postal Service and one of the major telecoms operators, does all the fixed lines, and of course they use a lot of trucks in their business. So they brought the claim only against DAF because they got their trucks from DAF, so they didn't sue the other cartellists. And they bring their evidence, the claimants, proving, as they seek to do their case, they have the burden of proof, and it's for them to decide how they're going to quantify the loss for which they are claiming. Almost inevitably, with a cartel, that involves the use of economists, and inevitably that means various economic techniques are used. It doesn't have to be a regression analysis, but that does seem to be one of the most established means of doing this, as many here know far better than I. There are other methods, simulation model, and so on. But regression analysis is frequently used, and looking at during and after, before and during, before, during and after, and then seeking to control for other variables that could influence the price. So that was done in this case, I think by both the main economists. The big problem in that case was the lack of independence shown in particular by the economist for DAF, who came in for a lot of criticism from the tribunal in a number of respects. Yes, one tends to start with the theory of harm in all these cases, and the theory put forward by the economic consultant used by DAF, not from CRA, I should make clear, was that the cartel had no effect on prices. This was regarded as somewhat surprising for a cartel that lasted for 14 years, involving 90% of the trucks manufactured in Europe and almost all the major truck manufacturers. But it was the way in which he went about his theory of harm. Let me read you just one very short little passage from the judgment of the tribunal as regarding The Economist. Professor X said that he had not asked DAF how it used the information obtained from the cartel. It was a broad exchange of information, cartels, most of you know. This is surely potentially relevant to any theory of harm, and his lack of curiosity in this respect is troubling. If he had asked DAF that question and had been provided with an answer, that would be relevant information that he would have been bound to disclose. But DAF's strategy has been not to adduce evidence about the internal operation of the cartel, and if Professor X had disclosed such information, DAF may have been forced to adduce factual evidence in such respect. We're not saying that we disbelieve Professor X's evidence that he did not ask these questions, rather that we have the uncomfortable feeling that Professor X's approach indicates that he may have become too aligned with his client and insufficiently independent. And there was rather more in that vein. And indeed, the result of that, plus the other significant failure by that individual that he failed to disclose that he'd previously been working with DAF for many years, and that was not disclosed in his report, meant that they actually did not accept at all his evidence as to the likely effect on prices. It was just rejected wholesale as being incredible.
So when it came to the judgment, the court was faced with these two expert reports, one claiming that there was no overcharge, and the other essentially claiming that there was a 10% overcharge. And then the court decided to apply what they called the broad axe. Perhaps you could enlighten us on what exactly is the broad axe and what was the reasoning then that led to the eventual 5% overcharge?
Yes, indeed. I'll do it in two parts. First, the broad axe, and then what happened in this case. The broad axe is a metaphor, in fact, comes from a Scottish case in the 19th century. It was then picked up by the House of Lords in a major judgment early in the 20th century, and basically means that when the court cannot come up with there's no basis to come up with a precise figure for damage, it should seek to estimate and come up with a broad estimation that seems fair. And if you think about it, that is inevitable and necessary, not particularly for competition cases, for all sorts of cases. I mean, imagine someone gets injured, a young man or woman in a car accident, they're a young lawyer or economist, they suffer terrible brain injury, they can never work again, they bring a claim for compensation in tort or delict. So the big question is, well, what earnings, future earnings, have they lost? What career would they have had? How would they have progressed? What might their salary have been in many years' time of their working life, which has now all been destroyed? There is no precise answer to that question. Indeed, no one really knows. So does the court therefore say, well, we can see you've suffered significant loss, but we really don't know what it is, so you get nothing? Would that be justice? Of course not. And so the court then uses, as best it can, what, in the expression used in that old House of Lords case, sound imagination and a broad axe, to come up with what seems a fair and reasonable figure. And just as you do that in that personal injuries case, or the House of Lords case was actually a patent case, so also in a competition case. So the claimant has the burden of showing beyond, on the balance of probabilities, that they have suffered significant loss, but they can't, on the balance of probabilities, show that they've suffered a loss of X thousand pounds or X million euros. So the court has then to come up as best it can with a figure on the basis of the evidence before it. And that was exactly the situation here. As with many cartels, you don't know what the competitive price would have been in the absence of the cartel. You know it's had an effect on price, and that's what they found. Hence the application of the Broad Act. So what happened in this case was, I've said, the evidence of DAF's expert that it had zero effect was rejected, and rejected because of the serious deficiencies in the way he went out developing his opinion. So his credibility was really, on that aspect, was very low. DAF's expert, the claimant's expert, joint expert, said 10%, as you said, based on his regression and various other methods. Where DAF's expert was more effective is in challenging some of the assumptions he's made in the regression and the way he dealt with certain issues. In particular, there was the question of exchange rates, because the list prices that were being discussed were in euros, the transaction prices in the UK were, of course, in sterling, and the way you dealt with exchange rates. So he made some valid criticisms of the claimant's expert on that point, and secondly, on the way you fed in the impact of the global financial crisis, which obviously affected demand and so on. Because of that, the 10% was considered to be too high. But it's clear that the claimants did suffer significant loss. Hence, the Broad Act comes into play, and the tribunal said, we will give you half what the claimant's expert has claimed. Not affected by the fact that DAF's expert said 0%. If DAF's expert had said 1%, it would still have been 5%. And it's explained, again, if I have a moment to just, and this case went on that very point to the Court of Appeal, where this was upheld, and they said this is precisely the sort of situation where wielding the Broad Axe is appropriate. It cannot be right for DAF to fail to disclose potentially inculpatory material which might have shed light upon the reality of its participation in the cartel and its impact on prices, and for its expert then to advance a case there was no overcharge when, as a rational business, DAF must have concluded that lengthy continuation of risky illegality was financially worthwhile. Its approach involves conducting litigation at the level of theory, not reality. The court is entitled to ask rhetorically how an appellant can complain when the cat plugs gaps in the evidence caused by that appellant by wielding the Broad Axe. And that's what they did.
So just to finish off the panel, I guess the important message is that it's not halfway between 0 and 10. It is which would give terrible incentives, of course, to future experts. But it's rather a discount, if you want.
Yeah, exactly. And on appeal, where that exact point was being made, that this is all unfair, they've just split the difference, they went into it in great detail to see that that is not what was done. It was starting at 10% and then seeing how much you should work down from the 10 because of the criticisms, some of them valid, of the claimant's expert, and just disregarding what DAF's expert had put forward because his credibility had been destroyed. But there's a great lesson, I have to say, for economists giving evidence, which is it really is important that you keep your independence and objectivity from the party that has instructed you and, of course, is paying your fees. May not be very modest fees, we know. Nonetheless, the duty to the court or the tribunal overrides that, and if an expert as that individual conspicuously fail to have regard to that duty, they can expect to be criticized in very harsh terms.
On that note, I would like to thank Judge Marcoulli and Mr. Justice Roth for the wonderful discussion we've had. Thank you.
Caps